Who remembers this woman?
Yes, I am Princess Califia Hatan Tupape II, representing the entity Dejon Anderson.
And you thought I forgot about her. No.
You're known as Dejon Anderson?
I'm representing the entity as Dejon Anderson.
Get settled in, everyone, because a lot has happened since we first visited this case several months back. Let's get to it. First, for those of you that are new to this case, let me fill you in on what's going on. In March of 2024, detectives with the Indiana State Police announced the arrest of Dejon Anderson. She is the mother of Cairo Jordan.
Earlier this week, Detective Matt Busick received information from a concerned citizen which started the path to physically locating Dejon Anderson, the mother of Cairo Jordan. Acting on this information, Detective Busick worked hand in hand with ISP troopers who are assigned to the U.S. Marshals Task Force and with U.S. Marshals themselves. And working hand in hand with them kept the U.S. Marshals abreast in California on the information that we were receiving and gathering. As a result of this information and investigative work, these officers, investigators, apprehended Dejon Anderson last night without incident in Arcadia, California.
This investigation actually began in April of 2022 when a man hunting mushrooms located a suitcase in a heavily wooded area in rural Washington County, Indiana. The suitcase contained the body of 5-year-old Cairo Jordan, Dejon's son. He was unidentifiable at the time of the discovery.
A 5-year-old boy found dead inside of a suitcase in southern Indiana has been identified, and now 2 suspects have been named in connection with the death. The victim's mother, Dejon Anderson, is wanted for murder. The body of 5-year-old Cairo Jordan was found inside of a suitcase in rural Washington County in April. Police were able to arrest a second suspect, Don Coleman, last week in California. Court records claim fingerprints from both suspects were found on a trash bag inside that suitcase. Right now, a nationwide search is underway for the victim's mother.
We desperately want the public's help in finding her and bringing her to justice. This whole case is all about justice for Cairo. That's the only thing this case has ever been about.
An autopsy concluded the boy died from an electrolyte imbalance, adding there was no obvious signs of trauma.
Now, fast forward to today. We previously touched on her first appearance in court just because of how strange she was. Here's a quick look.
Your date of birth?
My date of birth is February 2nd, 1961.
That would make you how old?
That'll make me 63 years old.
She's only 38 years old.
And the last 4 digits, your social security number?
I do not have a social security number. I have a declaration of nationality underneath the Ouachita Moors of the Indigenous People of the United Nations, Chapter 21593.
Do you intend to hire a lawyer, or is someone likely to hire a lawyer for you?
I want to file a motion for self-representation. The basis of my objection is the fact that I am not a fugitive. I have been under NSA surveillance for the past 8 months. And how can that qualify me as a fugitive on the run when I've also had a detail from Space Force that was following my every move?
Well, that's sort of interesting because it's my understanding Officer Busick has been in touch with almost every one of those agencies and they haven't been able to identify your location until recently. So I'm going to set your bond at no bond at this particular point in time. That if Space Force comes forward and tells me that they're willing to monitor you, we'll take up the issue of bond at a later time.
Okay.
Court documents revealed hundreds of pages of discovery in the case against Dejon Anderson. The prosecutor, Tara Coates Hunt, informed the court that the state's discovery included photos, text messages, body cam from police, interviews, and search warrants of numerous online accounts. This article was written on May 1st of 2024. The witness list contains nearly 36 law enforcement officers. It also lists Jeff Meredith, the mushroom hunter who found Jordan's body, Dawn Coleman, the other woman charged in his death, and an Indiana priest Anderson contacted about doing an exorcism on the boy.
Video tonight shows Dejon Anderson, Dawn Coleman, and Cairo Jordan in the hands of law enforcement just 1 month before the 5-year-old boy was found dead in a suitcase in southern Indiana. State police announced Dawn Coleman's arrest in October, charged with aiding in the boy's murder. On a blustery Saturday night in March, a South Carolina state trooper said this 2019 Dodge Challenger was going more than 30 miles over the speed limit. With sirens on, he chased for 30 miles until...
You think he ran out of gas?
They ran out of gas, and troopers used a pit maneuver.
Pit.
Eventually, the Challenger died.
Put your hands up!
They surrounded the car and repeatedly asked the driver, Dejon Anderson, to open the doors.
We're gonna bust the glass!
When the doors finally opened, troopers took out Dawn Coleman first.
Oh no, there's a baby right there. I don't have nothing.
Then they pulled out Dejon Anderson. With the two in handcuffs, they turned to the 5-year-old in the back seat.
What's his name? Jordan?
Cairo Jordan.
Here, hold your jacket, okay? Back out. Let's try to get you out of here. Y'all just ran out of gas.
Yes, that's why we were trying to hurry up and get
the Georgia.
Yes.
All right, ma'am, you are under arrest, okay?
A trooper asks for the child's name again, and Dejon tells him Cairo's name is Jason Jordan. Dawn Coleman says she's the child's aunt and can take care of him. The trooper makes a call and comes back with this.
I'm going to call Lieutenant. Okay. To see what you want to do with me. She's his sister. Just get the child, Jason, with you and get him up to the 33 at a hotel for the night until y'all got...
Dejon Anderson was charged with child endangerment and speeding. She paid her bail the next day, March 13th, and drove off. Cairo was found dead a month later.
Comes now, the court, on its own motion and being duly advised in the premises, does now find that all filings and correspondence from the defendant are hereby stricken. Furthermore, the court hereby finds and orders the defendant, Dejon Anderson, has criminal actions pending in this court. The defendant is currently charged in 3 counts of criminal conduct in this court with the offenses of murder, neglect of dependent resulting in death, and obstruction of justice. The information filed in this matter alleges that these offenses occurred on or about between the dates of December 1st, 2021 and April the 16th of 2022. I believe they said they thought that he was murdered like a week before he was found. I'm not even going to get into the other person in this trial, you guys. This is a lot.
The woman accused of killing her son, then hiding his body inside a suitcase in southern Indiana, is fighting her mandated psychiatric evaluation. In her initial court hearing, a judge asked for a psychiatric evaluation. Anderson plans to represent herself and is fighting that evaluation. She claims the evaluation is harassment and intimidation to cause a delay in her case. In handwritten documents sent to the court, Anderson wants her court-appointed attorney to be removed. Last week, the Washington County Judge Larry Medlock ruled before that she can represent herself, she must pass 2 psychiatric evaluations. Anderson was supposed to be in court on Thursday, but that has now been pushed off to June.
And that never happened. At the defendant's initial hearing on April the 2nd, the defendant requested to exercise her right of self-representation.
Clause number 88C01-2210-F1-833, State of Indiana versus Dejon Anderson. Under the influence of any drugs, including alcohol today?
No, I'm not.
You read and understand the English language?
Yes, I do.
If I say something you don't understand, will you let me know?
I will most definitely will.
Officer Busick, who's investigated this, looked for you for the past 2 years, and Prosecutor Hunt have charged you with 3 counts of criminal conduct. Count 1 is murder as a felony. Would indicate that between April the 10th, 2022 and April the 16th, 2022 in Washington County, State of Indiana, you did knowingly or intentionally kill another human being, that being child victim number 1, contrary to the form of the statute in such case is made and provided by Indiana Code 35-42-1-1, parentheses 1, and against the peace and dignity of the state of Indiana. Count 2, neglect of a dependent resulting in death as a level 1 felony, would indicate between December the 1st, 2021 and April the 16th, 2022 in Washington County, state of Indiana, you being at least 18 years of age and having the care of child victim 1, a dependent, less than 14 years of age, did knowingly place said dependent in a situation that endangered the dependent's life or health and which resulted in the death of child victim number 1. Count 3, obstruction of justice as a level 6 felony, would indicate that between April the 10th, 2022 and April the 16th, 2022 in Washington County, state of Indiana, you did alter, damage, or remove a record, document, or thing with the intent to prevent said item from being produced or used as evidence in a legal proceeding or an administrative or criminal investigation, contrary to the form of the statutes made and such case provided. The murder, a felony, has a range of imprisonment from 45 years to 65 years, with the advisory sentence being 55 years and up to a $10,000 fine. The level 1 felony, neglect of a dependent resulting in death, has a range of imprisonment from 20 years to 40 years, with the advisory sentence being 30 years and up to a $10,000 fine. And the level 6 felony has a range of imprisonment of no time in jail if it's treated as a misdemeanor to 2.5 years at the Indiana Department of Corrections, with the advisory sentence being 1 year and up to a $10,000 fine. Do you understand what you've been charged with?
I do understand.
In response to some erratic and non-factual statements made by the defendant at her initial hearing, the court also ordered Public Defender Alex Uli to represent the defendant. While attempting to argue against being held without bond, the defendant stated the following.
That's the issue of bond. Ms. Hunt, what's the state's position?
Yes, Your Honor. Given the gravity of this case, first of all, I would like for you just to take judicial notice of the probable cause affidavit that the state filed in support of these 3 charges, which resulted in the arrest warrant. I'd also like to bring to the judge's attention that it's almost a 2-year mark of officers locating this, at the time, unidentified little boy in the woods. So I would argue that the defendant has been a fugitive since that time. Her identification has been made. I think that raises any bond in a murder case to be something of the utmost importance and should be of an amount that should be very difficult, if not impractical, for her to be able to afford. I feel she will be abscond from this court. She's never been from Indiana. She's not from Washington County, is my understanding. She was located in California. So on that reserve, I would leave that to the court. And if further motion is needed on the state's behalf, I will make that.
Thank you, Ms. Anderson, you just made an objection.
Yes.
State the basis of your objection.
The basis of my objection is the fact that I am not a fugitive. I have been under NSA surveillance for the past 8 months. And how can that qualify me as a fugitive on the run when I've also had a detail from Space Force that was following my every move when I contacted the Indiana State to arrest me?
That is not a valid legal objection. If you want to represent yourself, you're going to have to learn the rules of evidence and the rules of procedure, because if you conduct yourself like this and make these types of objections, you have no chance in the world, lady.
Okay.
Following these statements made by the defendant in the initial hearing, the court reserves the right to decide whether to remove the court-appointed counsel based on the defendant's ability to display sufficient comprehension of her own representation and defense against the 3 causes of action pending against her in this court. Considering the prolific number of filings submitted by the defendant, as well as the content therein, the court finds the defendant has not displayed sufficient comprehension for self-representation and therefore has not removed Alex Uli as the defendant's court-appointed counsel. Furthermore, the court now questions the defendant's ability to represent herself in this matter.
Do you intend to hire a lawyer, or is someone likely to hire a lawyer for you?
I want to file a motion for self-representation.
You understand if you do that, you are required to conduct yourself as a lawyer to be able to board our potential jurors, to abide by the rules of evidence, to abide by the rules of procedure.
I do understand. I have a master's in history.
That doesn't give you a law degree, though.
But I do understand how to read procedures and understand the court procedures.
All right. Just because you represent yourself doesn't ensure yourself of a good lawyer, you know.
That's a personal opinion, but I understand.
Make your request in writing. Okay.
I will, most definitely. Can you give me at least just like 5 days and I could get it to you?
I can certainly give you 5 days to do that. Can you afford a lawyer?
It's not that I can't afford a lawyer. It's that I want to do self-representation due to I understand the nature of my case, and I understand that this is my life on the line, and I do understand that there are things that involve my case as far as the evidence that I hold, which is Q classified evidence, which should be turned over to Judge Advocate General Courts immediately, if possible, because my case involves other cases that are open currently with Judge Advocate General Courts, as well as federal investigations that are open.
Well, if the Judge Advocate General approaches us, we'll address it at that point in time.
Okay.
How about I appoint you standby counsel?
Oh, no, thank you.
No, thank you. All right. You make your written request.
The defendant filed a handwritten motion for dismissal on April the 8th of 2024. Since that first filing, the defendant has filed a total of 19 motions, 3 documents entitled Memorandum of Law, 9 affidavits, 9 pages of court correspondence, 1 letter of preservation addressed to Judge Larry Medlock, and 1 appearance into this case as a pro se party on June the 17th of 2024. And I've already looked back. I can't find any footage of that court appearance. So they may not have allowed anybody in the court. It says the defendant filed a handwritten motion for self-representation on April 9th of 2024. The motion cited unsubstantiated facts that are not relevant to her case. The defendant's motion for self-representation attempts to move the court to allow her to represent herself based on federal rules of criminal procedure, claiming matters of foreign intelligence. The defendant also asserts false claims that her court-appointed counsel, Alex Uli, is the grandson of President Joseph Biden. Since the filing for the defendant's motion for self-representation, the defendant refuses to speak or to cooperate with the court-appointed counsel, Alex Uli, because of the defendant's false belief he is related to the President of the United States. Due to the defendant's statements in the initial hearing and the allegations contained within the defendant's motion for self-representation, the court found it necessary to order a psychiatric evaluations to be performed by Dr. Calloway and Dr. Parker. This order was filed on April the 10th of 2024 and amended on April 15th of 2024. Since the time, defendant has been compliant with only one of the ordered psychiatric evaluations. The defendant's refusal to fully comply with this order has caused a delay in the criminal case. Defendant documents her refusal to comply with court order in an affidavit entitled Affidavit of Dr. Parker Visit June 12th of 2024. The defendant states in that I, Princess Khalifa Houghton Tupac Bey II, representing entity Dejan Anderson, met with Dr. Parker to decline his evaluation. Dr. Parker was in the law library. Parker refused to sign my affidavit to decline his evaluation. My evaluation of Parker is as follows. Parker exuded negative energy from his aura, which placed me in a defensive mode. I felt the need to protect myself and my thoughts. Parker is not a man of clear conscience. He presented himself as an expert of exploitation. Wow. On April 11th of 2024, the court submitted a waiver of attorney document to the defendant, which she refused to sign. In response to the defendant's refusal to sign the waiver of attorney document, the court issued another order on April the 16th of 2024. This order instructed the defendant to prepare her own waiver for review of the court. To this date, the defendant has defied this court order and has not prepared any waiver for review. Instead, the defendant's motion to vacate amended order for psychiatric evaluation filed on April 22nd of 2024, the defendant accuses the court of impropriety by stating, the court forced upon the defendant a waiver of attorney document, which was pre-filed, excluded rights provided to the defendant by the Constitution of the United States of America, IRC, and the Constitution of Indiana, displayed impropriety towards personal knowledge of the defendant. The defendant recognized the violation and refused to sign. Okay. The defendant's failure to comply with this order by the court has caused a delay in this case and further causes the court to question the defendant's ability to proceed pro se. None of the miscellaneous documents filed by the defendant specifically pertain to the 3 charges filed against her in this pending action or follow proper procedure. Defendant's filings state frivolous and meritless claims are largely conspiratorial in nature and are seemingly filed for the purpose of causing delays in this case. The defendant's documents engage in targeting, attacking, and harassing parties who are not involved in this pending action against the defendant. Subjects of her accusations are Washington County Clerk of Courts Stephanie Rocky, the defendant's court-appointed counsel Alex Uli, the Washington County Detention Center, Washington Circuit Court reporter Kelly Carl, and this court itself. The claims in defendant's filings include but are not limited to unsubstantiated allegations of criminal activity against these people and institutions. In these miscellaneous filings, defendant names Washington County Clerk of Courts Stephanie Rocky a total of 6 times. She repeatedly accuses Ms. Rocky of violating the defendant's due process rights and committing crimes of fraud, perjury, and destroying documentation. Defendant's handwritten emergency motion for discharge of defendant filed on June 6 reads as follows. I, Princess Khalifa Houghton Tupac Bey II, representing entity Dejan Anderson, known as the defendant, am requesting grant of emergency motion to discharge of defendant on grounds of Rocky, Clerk of Court, committing fraud on court, destroying order of dismissal, order of discharge, and not notating the special judge approved for case. Indiana Supreme Court on 5/26/24 sent orders by officer of court hand delivered. Rocky destroyed orders by having a paper shredder company come pick up all paperwork. How how would she know this? Like we know it didn't happen, but like isn't it weird that she thinks that she would know this? Rocky willfully and knowingly violated Anderson, the Fourth Amendment of the USC, and placed Anderson under enslavement, refusing to release Anderson from custody. In this motion, the defendant is referring to documentation from the Indiana Supreme Court that is non-existent and makes allegations that cannot be proven. Of these allegations, defendant states, I affirm and certify all allegations under penalty of perjury. The defendant makes Alex Uli, defendant's court-appointed counsel, the subject of her handwritten filings 13 times. She alleges in these documents that Mr. Uli unlawfully filed motions on behalf of the defendant and claims that he has been reported to the Bar Association. The validity of this claim is not currently known to the court. The defendant further makes repeated claims that Mr. Uli has placed her in harm's way. She says in the document, the court is allowing Alex Uli to openly violate IRC rules of professional conduct. The defendant provided to the court on April 11, 2024, allegations of Alex Uli having the defendant unlawfully detained in solitary confinement for using First Amendment to the United States Constitution, stating Donald Trump in the active commander-in-chief and the White House was stolen by Joe Biden, and not advocating for the defendant, protecting from severe abuse, pain, and suffering. The reports of severe abuse and pain and suffering include allegations against Alex Uli's family members that are employees causing said abuse, pain, and suffering. The defendant has victim of crime rights under blah, blah, blah. And she puts on there a motion to vacate the end order for psychiatric evaluation. Okay. In the defendant's affidavit of terms of representation by counsel, defendant again accuses Alex Uli of placing her in harm's way by suggesting he is the reason she is experiencing alleged physical ailments while incarcerated. The legitimacy of these claims are unknown to the court. This is what she says. I refuse to talk to Alex Uli without being fully represented within the court. Due to physical damage of losses of teeth, vaginal bleeding consistently over a 30-day period, my period being on twice this month, forced to bleed through my clothes due to officers' refusal to provide period pads, loss of muscle mass, and chemically burned throat from poisoning of food and contamination of air vents. Wow. In the defendant's amended motion for dismissal, she states, Alex Uli with Matthew Harris had the defendant placed in solitary confinement for mental health and self-harm watch issues for discovering an inmate and officer's sexual relationship due to intimate talking aloud about the defendant being placed under MK Ultra mind control. The defendant writes that she affirms and certifies the truth of the allegations under the penalty of perjury. Her claims are not confirmed with any verifiable evidence and remain unfounded. In defendant's miscellaneous filings, the defendant makes allegations of criminal acts against this court a total of 9 times. The defendant repeatedly accuses this court and its administration of fraud, impropriety, altering defendant's filings, violating defendant's rights, and harassment against the defendant. In multiple instances, the defendant even goes so far as to accuse Washington Circuit Court reporter Kelly Carl of causing, and this is her in quotations, detrimental harm to the defendant receiving fairness and the ability to prove innocence in trial. Kelly Carr provided one of the news stations with a fraudulent photoshopped incarceration photo, a photo from current detainment of the Washington County, Indiana, and details of a psychological evaluation before the defendant could be served. In the same motion to compel compliance, the defendant alleges the court has shown impropriety towards the defendant through bias, prejudice, harassment, negative stereotype, and extrinsic fraud. The defendant then threatens any further continuance of this case will be directed to the Indiana Supreme Court for judicial disciplinary actions pursuant to Article 9 of the Constitution of Indiana. The defendant's motion of relief due to violation of constitutional rights, the defendant requests $1.1 million in compensation and punitive damages due to the multiple occurrences of violations and acts of crimes by the administration of Washington County Circuit and Superior Courts. The defendant states damages for the physical and emotional harm as a result of violating my constitutional rights are righteous and fair. Punitive damages are necessary to defer future misconduct and hold the administration of Washington County Circuit and Superior Courts accountable to the highest extent of the law. The defendant later retracts this request in a motion to strike her own statement regarding a request for damages. The defendant, however, does not retract any allegations of criminal activity she claims has been allowed by this court and its administration. In a 10-page written memorandum of law, the defendant falsely accuses the court of denying the defendant an opportunity to achieve an attorney at their first appearance on April 2nd of 2024. The defendant continues in her accusation stating, now the court is in violation of criminal crimes and subject to disciplinary actions that can lead to bench being overthrown. In an affidavit for change of judge due to infractions and ordinance violations, the defendant accuses the court of coercion. The court coerced me into agreeing to a psychological evaluation in order for my motions to be heard, even though the court decided on my pro se motion. The court has not decided on the defendant's request for self-representation and will not decide until the completion of the psychological evaluations ordered by this court on April the 16th of 2024. The court finds that the defendant's multiple attacks on this court and its administration is a possible attempt to distract from the defendant's own criminal charges that are currently pending in this court. The court, however, is currently waiting for the expert opinions from psychiatrists before it determines what her motives are. Regardless, the court will not tolerate any further effort to impede court proceedings in this matter. The court finds the defendant's miscellaneous filings are what the court perceives as being founded upon conspiracy theories and not relevant legal facts. Some of the defendant's filings display what appears to be a distorted view of reality. In a June 6, 2024 filing, the defendant attempted to order this court and Washington Superior Court to produce 1. An order of special judge by Indiana Supreme Court, 2. Order for dismissal by Indiana Supreme Court, and 3. Order for release from custody by Indiana Supreme Court. The 3 documents listed in the defendant's handwriting, ordered to produce, do not exist. Furthermore, The defendant repeatedly mentions facts based in conspiracy theories that are completely unrelated to her pending case. In Defendant's 5-page handwritten affidavit of my injustice provided by the state of Indiana, the defendant writes, in Salem, Indiana, prisoners of war from World War II used the stolen money from the Rothschilds Bank to pay our American politicians and servicemen to be allowed entry into our beautiful country. The slaves of Caucasian descent slaughtered our great patriots, stole their names, and continued on with their Constitution. The slaves joined the army against the British to kill our own patriots to move up in ranks. Instead of the British dealing with their slaves like the great Tartanians, they shipped their prisoners here. The British could not admit fault for sleeping with slaves, creating spawn for evil worse than Satan's wildest dreams. Is it my fault that I was born to some of the greatest bloodlines? No, as I am forced to be around rapists, child molesters, incestors, drug addicts that use a title given to officers of law due to a dollar that says debt and the man who wanted a few more dollars to invest and grow his fortune. All I can say is God save America. In its April 16th order, the court stated it would not rule on any of the defendant's motions until the completion of the 2 ordered psychiatric evaluations. The court now amends this order due to 1. The erratic nature of the defendant's filings, the allegations contained in the defendant's filings, the delay in this case created by the defendant's refusal to comply with Dr. Parker's ordered psychological evaluation, the defendant's failure to submit a waiver of attorney document that meets the court's standard for self-representation as ordered by the court. The court reserves the ruling on whether the defendant can proceed pro se until after the court has received the competency evaluations ordered by the court on April the 16th. The trial court should not grant a defendant's request for self-representation unless it is satisfied that the defendant has the mental capacity to understand the proceedings. Another case that they stated there. The court warns the defendant that continued filing of motions that are not relevant to this action are non-compliant with the local rules of this court that do not pertain to the pending action in this court and or state baseless and unmerited claims attacking this court and its administration will additionally inform the court that the defendant should not be granted the ability to proceed pro se. It is the court's duty to see that this matter is tried fairly, justly, and in an orderly manner. This will not happen if the defendant continues to file motions, affidavits, and any other filings with statements of facts and accusations that are irrelevant to her case, such as the ones that she has been filing thus far. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. Peer versus State. The court reminds the defendant that if she wishes to continue to represent herself in this criminal trial, she is held to the same standard as a practicing attorney. In any future filings in this court, the defendant must file all motions in compliance with the Indiana Rules of Trial Procedure and the local rules of this court. The court orders that in any future filings, the defendant must file using only her legal name according to her birth certificate, as is the basis of self-representation. Yeah, no more Princess Khalifa stuff. The court orders that in any future filings, if the defendant mentions her date of birth in her filings, it must only be her legal date of birth according to her birth certificate. Because I think in her thing, what did she say? She was 60 something? The court orders that in any future filings, statements of citizenship must be filed using the defendant's legal citizenship according to her birth certificate as recognized by the United States government. The court orders that any future filings referencing any other cases filed by the defendant without documented evidence of the existence of those cases will be stricken. The court orders that any attempt to file any document addressed to any court other than the Washington Circuit Court shall be stricken. This includes, but is not limited to, any documents addressed to or referencing Washington Superior Courts, Indiana Supreme Court, and any other court not involved in this pending action. The court orders that any future filings submitted by the defendant must be founded on legal and substantiated facts. Any future filings that discuss the defendant's conspiracy theories and or are not directly related to the charges currently pending against the defendant will be stricken. While this court will make reasonable accommodations for self-represented litigants, it will not accept filings that are unrelated and irrelevant to the actions pending before it. All previously filed motions by the defendant since her election to proceed without counsel are hereby stricken as improper. The defendant is admonished that any future filings that do not comply with the local rules of this court and/or Indiana rules of trial procedure that are not completely related to the above referenced cause of action, cite baseless claims, attack individuals not related to this case, or attempt to disrupt and impede the proceedings of this court concerning irrelevant and nonsensical subjects shall be stricken. Whew. If the defendant wishes to continue to proceed in this case as a pro se litigant, the defendant must refile a new motion for self-representation that is compliant with the above stated regulations, as her original motion for self-representation is now stricken. However, the court will not rule on a new motion until the ordered psychological evaluations are complete. Right of self-representation is not licensed to abuse dignity of courtroom, nor licensed not to comply with relevant rules of procedural and substantive law. The court warns any future acts of deviance by the defendant against any order by this court may result in the defendant being held in contempt of court. That was written on July 3rd of 2024. So 2 months after the initial court appearance. They've attached the initial hearing, which we've already seen. This is the waiver of right form that they sent her, which she still has not signed. It was dated 4/11 of 2024. This is the order for the psychiatric evaluation. Dr. George F. Parker and Dr. Stephanie Calloway. And that was all dated April the 15th. Here is the letter that she wrote. Oh, no, this is a different one. Oh, all right, guys, buckle up. Whew. I, Princess Khalifa Hatan Tupac Debay II, I think that's how she says it, of Washington, Moors, Indigenous People of United Nations Chapter. Washington, oh, she's a Moor. Damn it. I just picked up on that. Sorry, didn't mean to scare y'all by screaming. Okay, I did a video not too long ago about the Moors, and they are considered a sovereign group. And there's a whole thing that goes back on the Moors, and I kind of wanted to dive into it a little bit. I'm trying to think of where I did it, where I put it. I think it was in one of my, it's going to be on my other channel. I dove into some sovereign citizen stuff in one of the videos. If I can find it, I'll attach it at the end of this. So she is representing the entity of Dejon L. Anderson, known as the defendant, and requesting the Washington Supreme Court of Washington County, Indiana, to dismiss, and she I guess this is her case, a level 1 felony neglect of dependent resulting in death, a level 6 felony obstruction of justice, a felony murder, so basically everything in her case, filed respectively on October the 14th of 2022 and October the 25th of 2022 on grounds of violation of the defendant's Fifth Amendment to the United States Constitution, which includes the Due Process Clause. And this is where she states that the Stephanie Rockery, knowing and willfully witnessed and sealed on October 25th an amended arrest warrant to command the arrest of her forthwith and hold the defendant to answer in the Washington Circuit Court of Washington. So she's saying that the clerk of courts is the one that had her arrested. Is that not some crazy stuff? Then she lists the counts. She says the state of Indiana did extradite the defendant from Los Angeles County Jail in the city of Los Angeles on March the 30th, arriving at Washington County Jail on March the 31st. The defendant is currently being held without bail in Washington County Jail. She names this the clerk of court again, used Rule 5.1 to file an information of felony against the defendant. Rule 5.1 states the government files an information under Rule 7 charging the defendant with a felony. Rule 7 is invalid for the defendant due to the defendant never appeared in open court prior to the initial hearing on April the 2nd for the indictment charges and never agreed to a waiver of prosecution by indictment after being advised of the nature of the charge and the defendant's rights. The indictment charges were provided to the defendant without a preliminary hearing by a magistrate judge to contest the charges by grand jury or judge on April the 2nd. At initial hearing, the clerk of courts disregarded federal rules of criminal procedure set forth by U.S. Supreme Courts and refused the defendant's right to due process clause contained within the Fifth Amendment to the United States Constitution. The clerk of court of state of Indiana Judicial Office has had ample time between October the 25th of 2022 and March 14th of 2024 to file a motion for correction to be considered good faith. So she's just putting a bunch of legal stuff here, basically stating that I'm gonna break this down because I don't want to read all this word for word, but it says that it's just naming the clerk of court several times here. The defendant was restricted from contesting the indictment of count 1, count 2, and count 3 previously stated on paragraph 1 of this motion, nor was the defendant advised of the right to a preliminary hearing due to the judge's assumption that I waived my rights of prosecution by indictment and presented the defendant with indictments at the initial hearing on April the 2nd. The defendant has legal rights protected by the United States Constitution, which, let's just make a point right here, because I always like to make this point. She doesn't follow the United States Constitution because she's a Moor. She's a sovereign citizen. So once again, they try to use the legal system only when it works for them. The defendant has a naturalization certificate that is located in DC number 52 at National Archives and Records Administration. The naturalization certificate gives merit to the defendant's citizenship status. So this is just a bunch of sovereign bullshit. So she's basically saying, it's false arrest. You knowingly and willingly witnessed and sealed a false document of arrest warrant for her. The defendant is asking the court to grant a motion of dismissal. I, Princess Khalifa Houghton Tabak Bey II, affirm and certify the truth of the allegations under the penalty of perjury. Now, she does put her Khalifa thing there, but below it she signs it Dijon Anderson. Okay, so then this is Lord have mercy. I might need to take a break. We're only on page 29, and there's 110 of these pages. Are y'all having fun yet? I definitely think I'm going to have to, when I put this out there, because I'm pre-recording it, obviously. When I put this out there, I'm going to have it set up so y'all can chat amongst yourselves while you're listening, because gosh. So in this summary of judgment, she referenced herself as Princess Khalifa, representing the entity of Dijon Anderson. She petitions the court for summary of judgment on motion for dismissal. There are clear and concise facts of violation of the defendant's Fifth Amendment by, and she names the court again, perjury offense of filing an information against the defendant as stated in the memorandum of law presented by Princess Bey II. Is it 2 or is it Bey II? I don't know. We should just nickname her Junior, maybe. I don't know. These facts demonstrate that there are no genuine disputes as to any mankind fact relevant to the claims presented by the defendant in this case. Motion for dismissal shall be granted under rule. The court may dismiss an indictment or complaint if necessary delay occurs. She's had someone help her write this, obviously, because she's putting it in a legal format. It looks somewhat legit, but obviously we know it's not. The summary of judgment is appropriate when there is no genuine issue of material fact and the moving party is entitled to judgment as a matter of law. I, Princess Khalifa Houghton Tabak Bey III, or the second, affirm and certify the truth in the allegations. Okay. So then this is where she put, this was April 9th. So this is where she put her handwritten self-representation thing, where she states, I relieve Washington County Public Defender's Office of their responsibility to manage my case due to a conflict in case. Public Defender Attorney Alex Uli is the grandson of Joe Biden. According to Rule 16, the defendant's oral statement, defendant's written or recorded statement, documents, objections, or foreign intelligence information that contain actions of Joe Biden as used in Rule 6. Foreign intelligence information means information whether or not it concerns a United States person that relates to the ability of the United States to protect against. Okay. actual or potential attack or other grave hostile acts of a foreign power or its agent, sabotage or unnatural or international terrorism by a foreign power or its agent, clandestine intelligence activities by an intelligence service or network of a foreign power or by its agents, information whether or not it concerns a United States person with respect to a foreign power or foreign territory that relates the natural defense or the Secretary of the United States or the conduct of the foreign affairs of the United States. So she's stating here that anything that public defender puts out there, it's null and void. He has been notified of termination on April the 8th at 4:44 p.m. via text through combined public communications provided by Washington County Jail. And again, she uses her name, her princess name, Princess Khalifa. She's requesting contact information for the prosecutor and judge to be included in all conversations, correspondence in regards to the cause, and to be present at all. Oh, she's pulling a Sarah. At all judges' chambers meetings as it relates to me exercising the Fifth Amendment to the United States Constitution. Motion to vacate administrative events. This might need to be more than one video. I don't know. This is a lot. There's a lot. She's requesting a motion to vacate filed against pro se motion. The administrative event correspondent stated summary denied pro se motion as she is currently represented by counsel. The administration, and she doesn't even spell it out. She's the admin, is willingly and knowingly committing perjury. Perjury willfully subscribes any material matter which he does not believe to be true. Is guilty of perjury and shall, except as otherwise expressly provided by law, be fined under this title or imprisoned not more than 5 years or both. This section is applicable whether the statement on subscription is made within or without the United States by violating the defendant's Fifth Amendment to the United States Constitution, includes a due process clause, which states that no person shall be deprived of life, liberty, or property without due process of law. This means that individuals are entitled to fair treatment, legal proceedings, and protections before the government can take away their fundamental rights or property on grounds that Judge Larry Medlock granted the defendant pro se open court motion and was waiting for the written request to be filed. She says the defendant followed the directions and instructions. The judge approved the representation of Washington County Public Defender's Office only if the defendant chose not to proceed with the written pro se motion. Therefore, the admin were to accept pro se motions by the defendant filed on April 9th on good faith and bound by Article 6 clause of the Clause 2 of the United States Constitution, commonly referred to as the Supremacy Clause. And she says that Alex Uli, the public defender, acted unlawfully by proceeding to the courts on April the 9th on behalf of her. Oh, she wasn't there. Okay. He had been fired on April the 8th using a certified device by combined public communications. In conclusion, Judge Larry Medlock order supersedes the actions of rejecting pro se motion by the defendant filed on April the 9th by the admin. The admin is on a second strike of committing perjury to infringe on the defendant's Fifth Amendments. Includes the due process clause. The defendant is requesting that the motion to vacate administrative event approved immediately at the judge's earliest convenience. The defendant is requesting Judge Larry Medlock to expedite answer in proceedings on motion of dismissal and motion of summary judgment within 7 days that were filed respectively on April the 8th. Answering the defendant's request immediately and effectively will defer misconduct and criminal acts willingly and knowingly pursued by the administration of Washington County Circuit and Supreme Courts. Any other something deemed just and proper by the court. The judge is bound by Article 6, commonly referred to as the Supremacy Clause. Jesus. All right, then on April 10th, this is her motion of relief due to violation of constitutional rights. Princess Khalifa, representing the entity of Dijon Anderson, known as the defendant, moves this court for relief due to violation of constitutional rights. The multiple occurrences of violations and acts of crimes by the administration of Washington County Circuit and Supreme Courts is astounding, to say the least. The details explained in the motion for dismissal, memorandum of law, motion for summary judgment, and motion to vacate administrative event violate my constitutional rights and warrant redress through this court. The injustice I have suffered through the Washington County Circuit and Superior Courts constitute a violation of my rights, which prohibits cruel and unusual punishment. The administration of Washington County Circuit Court and Superior Court's failure to provide good faith and protection. So, failure to provide good faith and protection constitutes negligence and deliberate indifference to my well-being. The fact clearly demonstrates that there are no genuine disputes available as to any material fact relevant to the violations of my constitutional rights. Oh, now she's serious. This is where she talks about the compensation. She wants money for the physical and emotional harm endured as a result of violating her constitutional rights. Punitive damages are necessary to defer future misconduct and hold the administration of Washington County Circuit and Superior Courts accountable. I accept any other relief deemed honorable and just by the court. I am requesting $1.1 million in damages to be served upon my physical being. I respectively request that the court grant the relief sought in this motion immediately to ensure the safety of my well-being and physical being, and provide redress for the violations of my constitutional rights suffered through the administration of the Washington County Circuit and Supreme Courts. Girl. Now, on the 19th, she files that motion to vacate the amended order of the psychiatric evaluation. I, Princess Khalif Bhutan Tupac Bey II, representing entity Dijon Anderson, known as the defendant, am requesting a vacating motion for order for psychiatric evaluation on grounds the court using influence of the judicial office to conduct impropriety towards the defendant. Okay. She says the actions of the court compromise and devalue the independence, integrity, and impartiality of the Indiana state courts. The court shall uphold the law and all rights provided under the Indiana Rules of Court, known as IRC. The court committed extrinsic fraud by violating, and she lists the rules that they violated. Then she goes on to list like the rules, the law as it is. She mentions preserving bias and prejudice by deciding orders for pro se motion and creating an evaluation to decide the mind competence of the defendant. The court held a hearing without notice to the defendant, nor notice into the chronological case summary. The court continually attacked and restricted the defendant from exercising IRC Code of Judicial Conduct. A judge shall accord to every person who has a legal interest in a proceeding or that a person's lawyer the right to be heard according to the law. Okay. She's basically pissed because they met without her. Then she brings up again how Alex Uli ignored he had been fired by her. The court forced upon the defendant a waiver of attorney document, which was pre-filled, excluded rights provided to defendant by the Constitution of the U.S. Girl. Displayed impropriety towards the personal knowledge of the defendant. The defendant recognized the violations and refused to sign. The court is allowing Alex Uli, the public defender, to openly violate the IRC rules. And she lists the rules. No counsel shall be in possession of medical records that was not provided by the defendant. That is an invasion of privacy interest protected by the Fifth Amendment, nor has the defendant provided written consent on release of medical records. The defendant provided to the court on April the 11th allegations of Alex Uli having the defendant unlawfully detained in solitary confinement for using the First Amendment to the United States Constitution, stating Donald Trump is the active commander-in-chief and the White House was stolen by Joe Biden, and not advocating for the defendant protection from severe abuse, pain, and suffering that is presently ongoing since March 30th of 2024 while being detained at the Washington County Jail in Indiana. The reports of severe abuse and pain and suffering include allegations against Alex Uli's family members that are employers causing said abuse, pain, and suffering. Good gracious. So not only him, but she's saying his family members. I have rights. The defendant has rights. Then she goes on to say, you already said that I was competent. So why are we going back? The court is demanding Dr. George Parker and Dr. Stephanie Calloway to violate the defendant's Fifth Amendment rights by providing private medical records to a court reporter. Therefore, amended order for psychiatric evaluation is a ploy of harassment, negative stereotype, and intimidation to cause delay in dismissal of case under IRC rules of trial procedure. Insufficiency of service of process. The court shall uphold and apply the law to ensure impartiality and fairness to all parties. Now, this is her motion to compel on April the 19th. Her motion to compel compliance. I, Princess Kalitha, blah, 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 representing NC Dejon Anderson, known as the defendant. The court was presented with the explicit statement of the facts by the defendant as a material of law. The Indiana Supreme Court recognizes the Indiana rules of court. She just keeps, spewing this same sovereign crap. The deep issues enacted by the administration of the court and the court have placed this case in demise. And as the law states, redress and relief is commanded. Y'all need to set her free. The court has failed to hold court officials and lawyers accountable for extrinsic fraud. The court has shown impropriety towards the defendant through bias, prejudice, harassment, negative stereotype, and extrinsic fraud. Again, she names the clerk of court. The court reporter caused detrimental harm to the defendant, receiving fairness and the ability to prove innocence. This is where she's bringing up again that the fraud went photoshopped incarceration photo, a photo from current detainment of Washington County, Indiana, and details of a psychological evaluation before the defendant could be served. The defendant was served a different order of psychiatric evaluation, and the court officially ordered the evaluation. Additional occurrences of extrinsic fraud were provided on April the 8th, April the 10th, committed by the administration of the court to the court. The court has jurisdiction to reprimand the administrative of the court under IRC. So she's asking for everything to be sent to the Indiana Supreme Court. This is an opportunity for the court to restore improprietary integrity and independence of Washington County Circuit and Supreme Courts back to the confidence of the public. Motion for time extension. The defendant is experiencing delay that is not in her control. Oh, she said that the United States Constitution is restricting me access to the file court's proceedings in a timely manner. So I guess because they're still kind of on the fence as to whether or not they were going to represent her, they hadn't given it to her yet. And these were one of her things saying, okay, well, you're just going to have to extend the trial then, because I haven't had enough time to go through my stuff. And she's just reiterating that here. All right, then on April the 29th, motion against the county jail. What happened in the county jail? This is going to get good right here, I think. Okay. I, Princess Khalif Hatuna Tipaka, Hatuna Matata. What is that song? Okay. The defendant is filing a motion against the Washington County Jail, Indiana, for using bras. Wait, for using what? Does that say bras? No. For using bias, prejudice, and torture tactics. Okay. For using bias, prejudice, and torture tactics to cause stalling in a fair trial for the defendant. The defendant had an argument with the captain, the lieutenant, and the OLC for their failing to submit her briefs to Washington County Circuit Court. The jailers became lawyers telling the defendant that she's not allowed to file briefs on her own behalf because she has an attorney. And then she read out loud the clause and articles to the jailers. So she's saying that one of the jailers called the Washington County Circuit Court and was advised to bring briefs to courthouse. The court granted the defendant the request to file motions on her behalf in order to the court. Okay, she's going back about that. Remember you said you were going to let me do this? Let's see. The defendant has a deadline to meet by the end of the day on April 29th. The jailers have refused to access the defendant's pod. The jailer, she put the number on there, has been placed in the control tower since before 1:30. Kitchen staff brought my lunch tray around 10:30. The defendant sent a request under general request form for a jailer to take briefs to the courthouse. The jailers can see whatever the defendant posts, for she has to pay to send grievances and forms. The jailer has to accept the payment in order for email to be sent to the correct channel. The email states pending payment until the jailer approves consent. I have been requesting a jailer since 11 a.m. My lunch may have been near my door since 10:30 a.m. The jailers are refusing to acknowledge my request spoken through the door. I've informed that the jailers are violating my First Amendment right. I have read previously how they are bound to uphold the law, being officers of Indiana. Again, she goes on to state that they're violating her rights. They're purposely causing delay in the defendant's right to fair trial. This fact is a manifest constitutional error that has the effect of an unculpable error. The defendant has warned the court of abuse and torture experienced by the jail. Oh, so here she's saying the court's not protecting her rights. Motion to strike. I think this is where she's motioned to strike that money. Wait, no. Okay. So April 29th, I, Princess Califia, whatever, memorandum of law is striked from the chronological case summary on grounds of invalid points referenced as it pertains to the state of Indiana legal system. I shake the sentence. Oh, she says okay. I strike the sentence that I am requesting the $1.1 million. Amend motion for dismissal. So I guess she's getting help, but she's getting some jail lawyer help, or she's reading up on some stuff and realizing where she's made mistakes and asking for things. Oh, she said that they're through illegal detainment. The defendant is entitled to certain rights due to birth occurring in Fort Worth, Texas, and the entity has a birth certificate issued from the state of Colorado. Oh, she's saying, this is where she's saying that the court reporter committed perjury. This is intrinsic fraud that led to Washington County Sheriff Department having the defendant detained unlawfully and illegally in Los Angeles, California, transported by Indiana federal marshals to Louisville, Kentucky, where Sam France and Matthew Harris, officers of the Washington County, Indiana, arrest the defendant at Louisville, Kentucky airport, transporting. Okay. Were cruel punishment, torture, and abuse is currently ongoing due to the Washington County Public Defender Alex Cooley having the defendant illegally placed on mental health self-harm watch, making falsified statements because the defendant trusted the court provided her with the effective counsel. And he's in violation of her rights. Alex Cooley, once fired on April 8th, presented himself at Washington County Court until the 9th, and the defendant told him that he could not have her motions denied in response of Uli stating the defendant could not file anything without him. The defendant told Uli not to speak on her behalf, and Uli had the administration of the court deny pro se motion in contrary of the defendant's wishes. And this is just, she just keeps hashing in on this. She's one of those, she's Sarah. She's got to say something. It says he had the defendant placed in solitary confinement for mental health, self-harm issues from discovering an inmate and officers. Oh, this is where she was talking about the inmates. She saw an inmate and an officer having relations, and that's why they put her in there. Why is it that all sovereign citizens sound like, I mean, it's conspiracy theories, but what do they call that? Paranoid. Paranoid. They all sound like paranoid schizophrenics. The defendant being placed under MK Ultra mind control. She says she's being held captive against her free will. In regards to her innocence of information of charges filed against her, the defendant is it that exposing similar mistreatment issues as reported in Maxis versus Layton, where Alex Uli was the settlement counsel defending Layton against accusations of mistreatment within their detention facility. Alex Uli worried for Boschel, Stroffer, and Grove. Oh, he worked for them. Okay, she names his attorney firm. Okay, she put the email in there. Uli also represented corporation defense in a civil matter in Roar International BV versus Smokies Tobacco Outlet. Those clients won their defense and had civil suits dismissed. Alex Dooley has proven to be ineffective counsel for parties defending themselves against criminal charges. In Harris versus State, Uli represented Harris, where the case was dismissed on grounds of improper processes submitted by Uli on Harris's behalf. Harris was charged with bribery as a result of Uli providing representation. The defendant is experiencing similar issues where the defendant's DNA was collected for a new case. What in the heyday? And another page is upside down. Damn it. So she's saying he's doing all kinds of stuff. Okay. Then she amends the motion for summary judgment. She's requesting summary of final judgment. There are clear and concise facts of fraud on the court, extrinsic fraud and intrinsic fraud committed by the court, the public defender, Alex Uli, the clerk of court, Stephanie Rocky or whatever her name is. The bias and prejudice experienced by the defendants are grounds making a fair trial impossible. These facts demonstrate that there are no genuine disputes as to any material fact relevant to the claims presented by the defendant. Amended motion for self-representation. She's requesting grant of pro se motion, and she's just complaining about the attorney again. She says, I formally terminated him for illegally detaining me in solitary confinement. Motion for change of judge due to infractions and ordinance violations. Okay, this one I do want to read. I'll read the full one on this one. Okay, she's requesting a change of the court per the IRC Rules of Criminal Procedure, that under IRC Rules of Criminal Procedure Rule 13, a special judge is selected by the Indiana Supreme Court due to the conflict of interest of allegations Dejon Anderson has made in regards to the employees of the court and the impropriety Anderson has received when WJC Indiana was deliberately violating her constitutional rights of access to books of law that were sent to Anderson, access to the physical and virtual law library, working with Washington County Public Defender Alex Uli to unfairly detain Anderson in statutory confinement from reportedly abuse and torture experienced while detained here at the WJC or the WCJ, the jail. For legal reference of infractions and ordinance violations, refer to these motions. Motion to vacate amended order for psychiatric evaluation. And memorandum of law, Anderson has yet to receive order of continuance from the notified court hearing of April 25th for pretrial conference from the clerk of court. And this is, I wonder if this is stemming from her being pissed because she wasn't brought into court on one of the hearings and her lawyer was present for her. And she said that he had already been fired. The facts presented by Anderson constitute particular circumstances. There is no genuine facts to dispute change of judge order as the request is made as a malfer or law. Good Lord. This woman, you guys, this woman, we're only halfway through this stuff. A receipt for the Indiana Office of Judicial Administration to grant a special judge to be appointed by the Indiana Supreme Court. They Again, she's saying they've used fraud to violate her, denying and withholding notifications, appearance of court hearings, ineffective counsel, and not offering relief of ineffective counsel, even though the counsel placed the defendant in physical, again, in physical harm. Oh, and now she's saying he leaked information. Who leaked information? Hang on. Who's an inmate relationships running leaked information from her case? The defendant has a current civil suit against WCJ. Do you? Do you, Princess Califia? Because I don't know if you do, girl. I think that they didn't accept any of that. The court has continued court hearings without the defendant being present. Anyway, she's saying the court's violating her rights again. I guess she feels like if she writes this enough time, the same thing over and over again, that eventually somebody's going to pay attention. I don't know. I don't think anybody ever did. She sends this to the United States Supreme Court, motion to dismiss. Grant dismissal by summary deposition of cause for writ of error. The motions to dismiss are based upon the ground that the Washington County Circuit Court has no jurisdiction of the case. Oh, God, here we go. Subject matter jurisdiction. This double action, or this double motion of the defendant is requesting the court to grant discharge of the defendant while awaiting a response. Okay, we'll just let you out. Oh, now she's saying she wasn't a fugitive because the public was never notified of said hearings. Oh, she's even put little spots for them to seal it and sign it. She's learning how to do this, I guess. Emergency motion for discharge of the defendant, June 6th of 2024. Princess Califia. I like Princess Khalifi better. Sounds like something out of Star Wars, doesn't it? In requesting a grant of emergency motion to discharge the defendant on grounds of the clerk of court committing fraud on the court. You guys, these are so crazy. I'm not even reading it. Oh, listen to this. The clerk of court destroyed orders by having a paper shredder company come to pick up all the paperwork. Dispatch employee left court jail grounds. Anderson overheard the jail. Okay, so then Anderson overheard the jail staff talking and laughing about her never getting out and plan of keeping said records and delivery envelopes to Sam. I have no idea what that was. She's under enslavement, refusing to release Anderson from custody. And she's saying she sued Rocky. Okay. All right, Califia. Order to produce, June 6th, Superior Court to produce the following documents. She wants a order of special judge. She wants an order for dismissal, an order for release. I think it's cute if it's her contact information on there. Because, like, girl, we know how to find you. You ain't going nowhere. Our emergency motion to discharge defendant continuation. Jeez, my knees. This was on June the 14th. She's claiming fraud, misrepresentation, and misconduct by adverse parties per the ROC rules of trial procedure. Okay, then this is her order. Dismiss the psychiatric evaluation, to vacate it. The motion to vacate it. She's saying they're devaluing Princess Bates II, representing entity Dejon Anderson. And here she's just stating laws. She's doing the same thing Sarah did. I don't know who did it first. Maybe she did it and Sarah's following suit. I don't know. They're not in the same state. I'm just saying. You know, it's like, I wonder why they do that. Are they doing that just because they want to, look, I want to let you know that I've read up on this. I know what I'm talking about. She says the judge has a personal bias or prejudice. She's listing all of her grievances and putting down the laws next to them. Which I'm not going to read this, you guys. Legal analysis of amend motion for dismissal and amend motion for summary judgment. She wrote this on April 29th. Wow. She's got so much time on her hands. I guess what else can she do? This memorandum addresses the legal issues surrounding amendment arrest warrant that provide cause for amend motion for dismissal and amend motion for summary judgment. The fraud on the court, extrinsic fraud, and the intrinsic fraud committed by the court, Alex Ulley and Stephanie Rockery, are violations of Indiana codes of law. And then she's putting out the definitions. I mean, it's all the same grievance. If you read this stuff, it's like her rewriting it over and over and over again. It's like, I should be released because of this law. Bloom. She's saying her arrest warrant was not signed by a judge on the bench. The arrest warrant used to detain Anderson was amended by the clerk of court. Is considered perjury. I wonder if there's any appellate attorneys out there that have looked at any of this and said, well, I might take this case. She's saying there's no way for her to have an effective, fair trial if one's attorney is proving with their actions to misrepresent a client. She actually might have had a case on her hands to get a different attorney if she wanted one. Of course, she just wanted to represent herself. But if she wanted to get a different attorney, she might have been able to do that if she'd have tried before she went off on this tangent. Motion for change of judge due to infractions and ordinance violations, because she's expressed to the court about the abuse she was receiving while detained in unofficial court hearings on April the 11th, and that I did not receive notification for an order for me to exercise my right for a fair trial proceedings. The court's response with these are no concern of that happens in the jail, but the court provided direct orders to the jail to accept my filings and provide me with personal law books. After 4 days of deliberation, the court felt that I needed a psychiatrist evaluation. The court coerced me into agreeing to a psychological evaluation in order for my motions to be heard. The time I filed my pro se motion, I did not have access to the Indiana laws and rules. I attempted to argue my points at the unofficial hearing on April the 11th as it pertains to the laws and rules of Indiana. The court refused to allow me to speak. I asked the court, is he just going to violate my amendments? And he replied he was protecting it. So she's claiming bias and prejudice. To order a mental evaluation due to my oration about NSA surveillance and used hearing from an Indiana state. Well, yeah, I mean, she realizes that's why. I guess she saw his order of that. I felt the court should have moved my case to federal courts due to lack of scope dealing with national foreign intelligence. I have no relief from the court from abuse and torture. I'm still experiencing at the hands of the legal representation, I think she says illegal representation, of Alex Ulley and the jail. I explained thoroughly with this case sightings how Ulley was not in my best interest. I do not take any prescription pills, drugs, alcohol, nor smoke tobacco, nor do I have mental health issues or feel like I will do self-harm. I am a certified Reiki master with certification to teach and a certified mystic. Oh, good Lord. And a 32nd degree Freemason of Prince Hale Lodge. I perform yoga and exercise at least 3,000 steps at a minimum of 3 times a week. I have refrained from eating processed sugar. Many of the food here at the jail has caused me to have tongue, throat irritation, as well as high count of sugar. After doing my research into the prosecutor, I found that I'm experiencing similar traits to Khan's, where Ulley represented them. Okay, so she's just going back on about that. Terms of representation by counsel. I fear for the safety of my life thanks to Alex Ulley and his hateful uncle, Lieutenant Frank, I don't know, at Washington County Jail, Indiana, even though the court indulges in ineffective counsel to represent me. I have never given him authorization to represent me or defend me in any filings without my prior consent. I refuse to talk to him without being fully present within the court due to principal damages of loss of teeth, vaginal bleeding, consistent over 30. She's already gone through that. I read about that already. Okay, we talked about that already. Psychological. Oh, this is the one I really wanted to get into. The psychological evaluation of 4:30. She wrote this on May 28th. Dr. Stephanie Calloway appeared before Anderson for a psychological evaluation on April 30th. Was authorized to speak to Anderson by kitchen staff. Then was later guided by the Lieutenant Sam Franks. I guess maybe what's going on is this Sam Francis or whatever he is, Francis or Franks, could be related. He could be related to Uli. I mean, that's a possibility. She may not be lying about that. But I don't think he's trying to do anything on her case any different than any other case. Then was later guided by him with his cell phone on to stand ground while Dr. Calloway conducted evaluation. Dr. Stephanie Calloway was presented with all filings by the defendant due to Washington County Court only providing a fee filing. Okay, so now this is her affidavit to decline psychiatric evaluation by Dr. George Parker, and it was done on May the 28th. It says the doctor appeared before Anderson for a psychiatric evaluation ordered by the court. Anderson did not agree to a psychiatric evaluation, only psychological examination per order of the court. Anderson activated her 14th Amendment and chose to remain silent. Affidavit of my injustice. Okay, this is the letter that she wrote to, I don't know. It sounds like she's writing it to her family. And I'm not going to read the stuff we already talked about, but she said it's mind-blowing to be a healer, a high priestess, receiving visions of the trauma and negativity that fill this place. I'm being forced to interact with unethical, unintelligent life forms of humanity. Now, the part that I wanted you guys to hear was, my case is the outcome of when humanity fails to understand how spirituality, knowledge, and our carbon bodies all work cohesively to establish our life here on earth. I completely understand why Salem, Indiana is being controlled by unethical humanity. At some point, you must understand that the statement, money is the root of all evil, in Salem, Indiana, pioneers of war from World War II. That's the way that she said that. Okay. I'm going to restart reading here because I can't remember if I read this part to you guys or not yet. Okay. My brothers and sisters will not stand for me because they do not want their lives uprooted from helping me. It's really disheartening to say the least. Imagine your child is saved by your mother from the people who kidnapped you and him, only for your brother to give him back to the slavemen, for your child to be sold to the highest bidder. You are blamed for his murder. Then you do the energy work, and the greatest soldiers of America find your son only to leave him without his mother's love because they have the lack of awareness to comprehend what truly happened. The details are so hard for them to believe that you were placed under the greatest mind control to mankind. Imagine only being able to give your child love in the other state of mind because humanity does not understand it was your strong beliefs in being a mother that saved your child. Imagine being so close to almost finding your son in California, like literally at the same business at the same time, and just missing him. Imagine the people you uncovered intelligence for on that their children can be safe, thought your child was better off raised without his mother, that fought so hard to ensure his safety. My patriotism was instilled into me from birth. Is it my fault that I was born to some of the greatest bloodlines? No, as I am forced to be around rapist children, and I've already read y'all that part. I want to read you the part where she's talking to her kids. If this is what I have to endure, for my two beautiful sons that I recently gave physical birth to and was able to raise for a few years due to all my other children I birthed were stolen from me, I am at peace. I hope that my children understand how destructive this world is and they keep themselves grounded and ignore the call to be patriots, just for them to be able to live a life of peace. Their safety will be tested many times just because of their bloodline. I am truly sorry that I created you into a world where righteousness has no place, even through the laws and justice proffers that righteousness exists. I am sorry that I am not allowed to physically be there to express the utmost love, but I am always there for you in spirit, no matter what this weird humanity does to my physical being. They can never defeat my soul. Stay away from these secret societies that our ancestors founded. You will end up like your mother. I know it will be hard. Please stay to yourself. Do not go and become these great men in sports or arts. Be someone subtle and play in the shadows in the background. Hopefully, our family members will keep you safe. You cannot really trust too much in that. Look at your mother's position and learn, baby, from my mistakes of loving a world who only loved to steal, rob, and cheat me out of the pleasures of life God gave to me. I love you all, my children, those through birth and those by IVF with different parents. Please take heed to everything I express, even if you were not raised by me. Have the strength of U.S. Steel, have the courage of a lion, have the knowledge of an orca whale, and have the love for self. Only you matter, and the decisions that you make will affect the outcomes of your future. Isn't that crazy? Affidavit of Dr. G. Parker. You know what I find it really insane after flipping through all this and reading it? Now, I know I have different handwriting at different times, right? I think I do. I have a sloppy and then I have a semi non-cursive and then a cursive but I swear this woman's got like 3 or 4 different handwritings. She's saying she met with the doctor to decline his evaluation. Parker was in the law library. Parker refused to sign my affidavit to decline the evaluation. My evaluation of Parker is as follows. Parker exuded negative energy from his aura, which placed me in the defense mode. I felt the need to protect myself and my thoughts. Parker is not a man of clear conscience. He presented himself as an expert of exploitation. It says Parker showed immediate offense of Bay 2, expressing her concern to remove himself immediately in concern of his belongings being safe and secure, which is logical to conclude after being in his facility and what Bay 2 has endured as. Oh, so she's saying he's like, she's basically saying he's in on it with all of them. Parker used a threatening tone towards Bay 2, stating a matter of opinion, but never once made a reference to a legal case nor law to back his opinion. Parker began to bully Bay 2 into believing that he had this godly authority over her case to decide if one can represent herself. Parker was very agitated with Bay 2's, stating all court's orders can be contested and she has that right. Parker made a statement to Bay 2 about her residence in the facility. Parker was allowed to make observation of Bay 2 while she was in mediation and prayer with God within her cell through camera in secret. I have the right to express my religion of Christianity in any manner that I see fit. So even though she says all this other stuff, she still thinks she's a Christian? This is blowing my mind. I don't know where this, guys, I don't know where this woman's come from. I understand that Parker was not prepared to speak with Bay 2, for he had limited documentation of Bay 2 writings and did not have knowledge of orders of the court. And that was it on that one. Sent to release confidential court records. She says she's a party affected by confidential court records in this matter. I affirmatively consent the release of otherwise confidential court records available to somebody to or for public access. She's filing her consent in writing. That's pretty much it. Oh my word, what is this? Affidavit of God's dominion over this criminal matter. Oh my gosh. Okay, I really think this is it anyway, because this other stuff is just. Oh, there was a letter to the judge that we're going to read. Okay, let me go back to page 98. 2 more pages, guys. Bear with me. I know. It's brutal. Look, if I had to listen to me read the stuff, and I don't know if I would have stuck around as long as you have at this point. God bless you. I wish I had a better way. I wish I was more patient in presenting this all to you, but I'm not, and I apologize for that, but I just can only take so much of this. Okay. Because I'm already past my deadline on how much time I was going to spend on this one. Okay, so she, Princess Khalifa, am writing to an affidavit about my rebirth of my soul through Jesus Christ back to God, the greater power. Ooh, listen to this, guys. I want to thank Judge Medlock for doing whatever necessary to keep me from proving my innocence and keeping me incarcerated. I definitely was in need of this moment to turn back to God, as those connected to my case were seizing powers of darkness. I'm not sure what this word is right here. I'm thinking it's seething or seizing powers of darkness. My God came through like no other. As John 3:16 stated, God provided his love, his son Jesus Christ, to save the world from damnation of men. I've been made whole. As you can see, I can do all things through Christ that strengthens me. While Judge Medlock sent, I want to say, man to judge me, God sent his word to guide me into understanding more of my gifts. 1 Corinthians 14 will give you insight on my many gifts that God has bestowed upon me. God has invested upon me the power to trample all souls that serve the Antichrist, per Luke 19. 1 Corinthians 10 will teach you to not use your position to disobey God and provide us of examples as unto why we should obey God. I trust in God. He is my provider, my father, my mother, my guidance, my counselor, my protester, and the list goes on. Wow. She, y'all, she just thinks she's above it all. I can't sit here and read this. Because I can't, this is like blasphemy against the Bible. I mean, if she believes in God, good, but I think she's got a total misrepresentation here of God, obviously, because she thinks she has powers or whatever, but you guys. Whew. Well, let me put it this way. It was 110 pages. I didn't touch on every single thing on all 110 pages because a lot of it was repetitive. This is my review of this case. And as of today, she's in a psych hospital and she is receiving treatment. Let's hope she's doing well, even though she did such horrible things with her child. I do think that this woman has tremendous mental illness, and it could be that she stays in there forever. It could be that they find out that she's just playing a game with all of us. I don't know. But until something else comes up on this case, I'm going to close it out for right now. The sad thing about this is that Cairo Jordan is the one that is lost in all of this. This young child, we don't know what he went through. We don't know what his little short life was about for him. But hopefully there are family members that are just being brought together in love with what happened, and they're able to get some peace in this case. And maybe they do get peace knowing that she's gone to a psychiatric hospital, because maybe all along they've known that's where she belongs. They probably would never show us, but I would wonder if any of the family members wrote to the judge in this case about her and what was going on with her. Because I'm sure if she is truly mental and if she's not just faking it, then they were well aware that there were problems all along. Okay, I'm going to close this one out.